Definition of Sulh. Imam An-Nawawi defines Sulh as ending dispute from an Arabic word, salaha, which means to be good or suitable. Al-Mawsu'ah Fiqhiyah summarized the meaning of Sulh by classical scholars as mutual agreement to resolve the dispute between the disputing parties through amicable settlement. Next, history of the application of Sulh in Malaysia. The Malacca Digest as an applicable law effect the practice of the Malay society during the Malacca period as that law adapted to other state laws such as law of Kedah and the 99 laws of Perak. Implementation of Sulh can be seen in chapter 32.2. Next, the implementation of Sulh proceedings in the Syariah Court. In 2001, the Selangor Civil Procedures 2001 Sulh Regulation were formulated. An effort was made by the Selangor Syariah Courts to establish Majlis Sulh in 2002, as shown the importance of Sulh and responding to the National Seminar on Alternative Dispute Resolution. 11 Sulh officers have been appointed, which is 8 male and 3 female. However, they have no formal training to conduct the Sulh session at that time. In 2002, the first workshop was held and attended by these Sulh officers where the Sulh manual were drafted. In December 2006, an accord group conducted the training to the Sulh officers to improve their skills in mediation. Next, types of Sulh implemented in the Sharia courts. There are few types of Sulh conducted formally and informally, such as Sulh for dissolution of marriage, Sulh in the legal aid department, Sulh conducted by Syar'i lawyers, Sulh through Sulh officers, and Sulh conducted by family support authorities.
I will continue to procedure of conducting the Sulh Council or Majlis Sulh in Sharia Court in general. First of all, according to Practice Direction Number 1, 2010, there are 18 claims that should be referred to Majlis Sulh before the court trial. Next, the procedure of Majlis Sulh according to Practice Direction of Sulh or Manual Kerja Sulh, which is prepared by Department of Syariah Judiciary Malaysia. Firstly, during the ta'aruf, the Sulh officer should introduce himself and each parties, and then started the Majlis Sulh, the Sulh session, with recitation of Al-Fatihah and prayers. Lastly, after hearing the explanations from the parties, the Sulh officer should prepare a conflict map to identify the scope of the dispute between the parties. And the Sulh officer also needs to identify the causes leading to the conflict, the obstacles that exist, and the actions that need to be taken to reach a solution. Which means the Sulh officer should summarize what are the matter of the problem, and then lead them to reach their own solution between the suggestions from both parties, so that they can reach a mutual agreement, and the Majlis Sulh can be considered as
there are 4 legal provisions relating to Sulh in the Federal Territory, which are Sharia Court Civil Procedure Federal Territories Act 1998, second Sharia Court Civil Procedure Federal Territories Rules 2004. Okay, as we can see, the Sharia Court Civil Procedure Sulh Federal Territories Rule 2004 has 9 rules in works the Sulh in the Federal Territories, which I mentioned just 3 of them, which is rules number 3 is about fixing date of Sulh, rules number 5 about the procedure for Sulh, and rules number 8 about the hearings. Alright, so the third legal provision is, as we can see, practice direction of the Department of Syariah Judiciary Malaysia, which is we known as JKSM. And lastly, before that, JKSM is to help indicate specific procedure used that are not found in the rules of civil procedure. Alright, the last one is the Sulh Work Manual, which was also created to streamline the administration of the Sulh process in Malaysia. Alright, lastly, as you can see in this statistic, that the handling cases for claim through the Sulh in the Federal Territory Sharia Court for the year 2014 showed that 49% successfully and 28% finished but did not absent, and 23 is finished but failed. Alright, This means the acceptance of the Syariah Court in the use and application of the Sulh Council is seen as a very encouraging, as been highlighted in this.
Next, we move to Selangor. In general, the application of Sulh in Selangor is governed by these laws and procedures. First, the Administration of Islamic Religious Enactment 2003. Second, the Sharia Code Civil Procedure Enactment 2003. Third, the Civil Procedure Sulh Rules 2001. Fourth, the Islamic Family Law Enactment 2003. Fifth, the Sulh Work Manual. Sixth, the Sulh Officer Ethical Code. 7. The Selangor Sharia Court Chief Justice General Order 9. 8. The Practice Direction JKSM 3, 7 and 8. The table shows the Sharia Court Sulh registration statistics in all states from 2013 until 2017. In conclusion, the impressive statistics of Sulh, particularly in Selangor, should be taken as an indicator of the viability of Sulh as a dispute resolution mechanism and justification for the extension of Sulh in Sharia courts all over Malaysia.